Good afternoon, everyone. I'll be speaking about the recent Delhi High Court case, FMC Corporation and ORS versus Natco Pharma Limited. So, the plaintiffs FMC Corporation and FMC Agro Singapore Private Limited were assigned an Indian patent that was for a method for making CTPR. The claimed method essentially involved combining a carboxylic acid, an aniline compound, and sulfonyl chloride to obtain CTPR. The defendants, Natco Pharma Limited, had also planned to manufacture CTPR, and their process involved combining a carboxylic acid, an aniline compound, and thionyl chloride to obtain CTPR. The plaintiffs had sued the defendants, saying that the defendant had infringed the plaintiff's patented process for making CTPR under the Doctrine of Equivalents. Now, the rule for Doctrine of Equivalents is that even though there isn't literal infringement, there can still be infringement if in an allegedly infringing product or process, a substituted element does the same task in substantially the same way to accomplish substantially the same result. Now, there is no infringement if an essential element is omitted. In other words, this substitute element has to be in a way essential to the equivalent in the patented product or process. Now, given that the plaintiffs had sued the defendants for infringement under the Doctrine of Equivalence, the issue for the court was to decide whether that was the case. And just to give you a recap, the plaintiff's process was combining an acid with an aniline compound and sulfonyl chloride to obtain CTPR, and the defendant's process was combining an acid with aniline compound and thionyl chloride to obtain CTPR. So, in order for the court to determine if the defendants did infringe under the Doctrine of Equivalence, the court first looked at the sequence in which the plaintiff's process and the defendant's process had occurred. So, as plaintiff's process simply said combining the acid with aniline compound and the sulfonyl chloride, this combining could occur in various combinations. So, for example, you could combine the acid with the aniline compound first and then combine it with the sulfonyl chloride, or you could combine the acid with the sulfonyl chloride first and then combine it with the aniline compound. And like that, there were various orders in which you could perform this combining. So the court wanted to see whether the combining or the sequence in which the plaintiff's process had occurred was the same as the way the defendant's process for combining the reactants was the same. Now, after looking at this, the court would then look at whether sulfonyl chloride was an essential element. And if it was an essential element in the plaintiff's patented process, they will look to see whether the thionyl chloride in the defendant's process was an equivalent to sulfonyl chloride. So for the first part, to determine whether the sequence in which the plaintiff's process and the defendant's process for combining the reactants was the same, the court looked at the written description of the plaintiff's patent. And the plaintiff's patent in the written description had disclosed a preferable sequence for combining the reactants, which involved combining the acid with the aniline compound first, and then combining it with the sulfonyl chloride. Now, even though the written description for the plaintiff's patent did not limit itself to just the preferable embodiment, the written description had stated that there were several orders in which this combination could occur. And even in the claim of the plaintiff's process, it simply said combining this first reactant, second reactant, and third reactant to obtain CTPR. It did not limit itself to a certain sequence. But yet, the court, when interpreting Claim 1, had narrowly interpreted it to that of the preferable embodiment. Now, using that interpretation, the court compared it with the defendant's sequence in which the reactants were combined. And there the court noted that in the plaintiff's process, there was just a single reactor used, whereas in the defendant's process, there was 2 reactors. And in the plaintiff's process, where the acid was first combined with the aniline compound and then the sulfonyl chloride, in the defendant's process, the acid was first combined with thionyl chloride, and then it was combined with the aniline compound. So the court noted that there were differences in which the reactants were combined in the defendant's process and the plaintiff's process. Secondly, the court then looked to see whether the sulfonyl chloride in the plaintiff's patented process was an essential element. That is, whether it was necessary for the manufacture of CTPR. And here, based on the written description of the patent and also based on the advice from the scientific advisors, the court found that, yes, sulfonyl chloride was an essential element. So the next step for the court was to check whether the thionyl chloride was an equivalent of sulfonyl chloride. So here, the court basically gave deference to the opinion of the scientific advisors. Here, the scientific advisor said that that thionyl chloride was different than sulfonyl chloride for the following reasons. The first one was that thionyl chloride is an inorganic chloride, whereas sulfonyl chloride was an organic chloride, and as a result, it had different physical and chemical properties. The second thing was that thionyl chloride in the defendant's process acted as a chlorinating agent, whereas in the plaintiff's process, the sulfonyl chloride acted as a coupling agent. So in other words, it was performing a different function here. And also the chlorides were performing in a different manner as well, the associated function. Third, you have to look at whether the result that is obtained by the different processes are the same. And even though CTPR was obtained in both of the processes, the court noted that in the defendant's process, you could obtain certain substances that have use in the food and cosmetic industry. Whereas in the plaintiff's process, the other substances that were produced were actually hazardous to the environment. So based on all of this, the court found that there was no infringement under the Doctrine of Equivalents. So what takeaways can we get from this case? One practical takeaway is essentially to refrain from explicitly referring to an embodiment as a preferred one. Now, even though the Patent Act says that we have to disclose the best mode for performing an invention, we can include it in the written description, but we don't have to explicitly refer an embodiment as being the best one, because then that could allow the court to narrowly interpret the claim into that of the preferable embodiment. The second takeaway is that even though the court had looked at the difference in the sequence of which the reactants were combined, it is unclear whether the difference in the sequence in which the reactants were combined was sufficient to give rise to a finding that there was no infringement under the Doctrine of Equivalents. So that is a lack of clarity that I had found from this case. Thank you for listening.
Nikhil, one question I have is the process of identifying essential and unessential elements in a claim. Isn't it the second step while determining Doctrine of Equivalence? When the elements differ, for example, let's say the all elements rule is not satisfied through literal infringement, and there is a differing element, then the next question would be whether this differing element is an essential or unessential element, right?
Correct. Which the court had performed, which the court didn't exactly perform, but they had looked at the written description to see whether, the sulfonyl chloride was essential for performing CTPR in the plaintiff's process. And they had also looked to the scientific advisor's opinions, and they also said that sulfonyl chloride was essential. And then only they looked to see whether thionyl chloride was the equivalent of it, essentially.
Yes. I think in terms of what happened in the case is one thing, but what I am trying to understand is from the point of view of assessing infringement by equivalence. So the first step would be to identify the differing element, then second to see if this is an essential element, and then see if there is the differing element is equivalent, right? That's the
correct. That is the sequence.
Yeah. But I mean, if my memory serves me right, didn't the scientific advisors differ in their conclusion?
No, sir. I think both the advisors had found that in this case that thionyl chloride was not the equivalent as that of the sulfonyl
infringing
chloride.
by equivalence. Yeah.
Yes, it was not infringement under the Doctrine of Equivalents because they were both
sorry, yeah,
different.
yeah. Okay, fine. So both of them gave the opinion that it was not infringing.
Correct, sir.
Okay, all right. Thanks, Nikhil.